Cash-strapped SAA has been dealt another blow. It has been ordered to pay Nationwide Airlines 104.6 million rand plus interest for anti-competitive conduct. The case is the first of its kind to be heard in a South African court and sets a precedent that could open the floodgate for future claims.
Joining us on the line now to discuss the details of the case and for a closer look at what this ruling could mean for other airlines with similar claims is Lucinda Verster, a partner at Bowman Gilfillan who represented Nationwide in the court proceedings. Lucinda, thanks very much for your time.
Thank you.
Lucinda, perhaps you could explain firstly why it is precedent-setting as far as litigation is concerned.
Sure. So basically this case has got quite a long history. The first complaint against South African Airways was filed before the competition authorities by Nationwide way back in 2001. SAA was found to be guilty of abusing its dominant position and got fined 45 million, and Nationwide instituted the first claim in 2005, which was heard and settled shortly after the trial commenced in 2006. Obviously, SAA continued with its abuse, and a second complaint was filed by Nationwide together with Comair, and SAA was found again to be guilty of prohibited practice, and Nationwide filed a second damages claim in 2010. That matter was heard before the High Court this year in February, and we obviously got judgment on Monday. So basically it's the second of its kind, but it's the first to be litigated in South Africa.
And this against abuse of market dominance, unlawful conduct. So what exactly, Lucinda, are we looking at here?
Sure. So basically in terms of our Competition Act, Section 8 of our Competition Act says that if you're a dominant firm, you cannot do certain things. And one of it is you cannot induce a supplier not to deal with a competitor, which is exactly basically what SAA has done. So we all know that SAA is dominant in the market. They were found to have a market share of more than 45%, which means that they are deemed dominant. And what they did is they paid commissions over and above the standard commission to travel agents to divert business away from competitors such as Comair and Nationwide towards SAA.
Lucinda, Comair was a co-complainant along with Nationwide. How big is their claim?
Correct. So basically they were co-complainants and their damages claim was heard in April. Final argument in that matter is set down for some time in August. Their claim, obviously being quite a bigger airline than Nationwide at the time, is about 4 to 5 times the amount that Nationwide claims for.
Of course, this sets the precedent for that claim by Comair against SAA for the same conduct. So to what extent does this now bolster that case?
Absolutely. The judge in that matter will no doubt have regard to our matter, because, like I said, it is a precedent, and he has no choice but to have regard to this decision.
Lucinda, just going back to the length, the duration of this, I mean, as you said, the first claim was lodged in 2001, and it's taken until 2016 to get a judgment in the High Court. But from the second claim of 2010 to now, there was obviously interest involved. How did the judge, perhaps you could talk us through how the judge arrived at the determination of the interest payment, because going through the Business Day article today, the judge ordered that interest is payable from the date of judgment, as opposed to the date that the tribunal issued a certificate of anti-competitive conduct. What are those two different dates, and what bearing does it have on the interest payments?
That is something that the legal team is considering at the moment, because our Competition Act makes it quite clear that you can claim interest from the date of the issuance of the certificate. So that is something that we are discussing at the moment, and how to deal with that issue, because obviously we are entitled on interest from the date of the certificate and not date of judgment in terms of the Competition Act.
What are those two dates? Because perhaps you could give us an idea of then the quantum of interest.
Sure. The certificate was issued 24 February 2010. And the judgment date was Monday, the 8th of August this year.
Okay.
In totality, Lucinda, how's this actually been quantified, the amount of damages to be paid? Because something that was highlighted is the courts acknowledging the shortcomings, for example, in Nationwide's safety record as well. So there are numerous variables to be taken into consideration here.
Absolutely. And as you can imagine, the most important evidence that was led was economic evidence. Both ourselves, on behalf of Nationwide, and SAA had expert economists from overseas to basically quantify the damages. what the court found is basically what we are dealing with is the market for travel agents, because obviously it was travel agents diverting business away from Nationwide and coming towards SAA. So what the judge found is that 75% of the market was basically travel agents, and then the other 25 were direct sales or internet sales. So what they said is Nationwide basically were foreclosed of 75% of the airline market. But there was a lot of economic evidence that was laid on this score.
Lucinda, how confident are you that SAA is going to pay the damages?
Well, first of all, in terms of the law, they do have some time, 15 business days, to note an appeal if they so wish. So they can either pay or they could appeal. But at this stage, it is not certain what they would do.
Okay, so that one of, the X's in the equation. The other X is, to what extent you see this actually changing SAA's behavior? Because, as we say, we've been dealing with the matter over the past 14 years. It's been tried once before. It's paid a penalty once before. And this, again, now coming to the fore.
Absolutely. So basically, as you know, Nationwide was liquidated in 2008, and we instituted the damages claim in 2010. That was basically the end, if I can call it, of the Nationwide applications or claims against SAA. Whether or not it is something that is still operating in the market, these agency agreements, I would not know. Because obviously I'm acting for the liquidators at this point and not Nationwide Airlines, who obviously also deals with travel agents, etc. in the market. So we are not sure whether or not the conduct is still continuing or whether or not it has ceased.
And then, Lucinda, just on that point, Nationwide, you are acting for the liquidators. So how are the money settled? I mean, do Nationwide's, I suppose, creditors get back some money as a result of this judgment?
Correct. It will go to the creditors, one of whom is Mr. Vernon Bricknell, the former CEO of Nationwide.
Okay, let's leave it there, Lucinda. Thanks so much for having joined us on the line today. Lucinda Verster is a partner at Bowman Gilfillan. Well, after all that legalese, let's end things off with our quirk of the day. North Korea has proposed a radical approach to speeding up infrastructure development, making crystal meth freely available to workers.
The country is hoping to build a 70-floor skyscraper and more than 60 apartment blocks as it seeks to prove that it is a developed country.
But construction is just not happening fast enough for its leader, Kim Jong-un. And so contractors have decided to increase energy levels by supplying employees with crystal meth.
The drug's been made locally at state-run facilities since the 1970s and so can be accessed readily and cheaply.